It took some time, but the bid to legalise the private use of cannabis has just cleared a major hurdle. 5 years after the Constitutional Court decriminalised the private usage of the herb, the National Assembly this week adopted the Cannabis for Private Purposes Bill. Russ, that's Gareth Prince, is the chairperson of the Cannabis Development Council of South Africa. He joins us now via Zoom from Cape Town just to give us a reaction to the adoption of this bill by Parliament. Russ, Gareth Prince, good afternoon and welcome to today. Your reaction to the news that finally Parliament has given the green light.
Good afternoon, Brother, and a very warm welcome to all of the ENCA viewers. 5 years has been a long time, Brother, and unfortunately we cannot say that we are happy. It would seem that when it comes to bills that predominantly affect the indigenous people of this country, our Parliament does not do us right. We will bear witness to the fact that the Traditional Healers Practitioners Act, the Community Land Restitution or Land Rights Act, the Traditional Leader and Khoisan Act has all been found unlawful after it was passed by this National Assembly to have been unconstitutional because either they were brought in the incorrect way to Parliament or Parliament failed in their duty to facilitate adequate public participation in respect of these bills. And unfortunately, those same mishaps happened in relation to the Cannabis for Private Purposes Bill. So in the form that the bill was passed by the National Assembly, it would seem that we are heading back to court, which is really unfortunate because it is the duty of the National Assembly to adopt a law that would serve the people of South Africa.
What misgivings do you have about it and why it could face legal challenges in court?
There are two fundamental flaws in this bill, Bradan. Number one relates to the fact that Parliament decided to tag this bill as a Section 75 of our Constitution bill. That means it is supposed to be a bill that falls exclusively within the national competency to draft legislation and is said not to affect the provinces. And it was also said to be, by virtue of its Section 75 tagging, to be a bill that need not pass the National House of Traditional Kings and Leaders. Now, that is an absurdity with all due respect, Bradan, because this is one particular bill that indeed impacts on the manner in which provinces actually relate to the bill, and therefore these provinces needed to have had maximum input in the development and the conceptualization of this bill, which unfortunately did not happen. And then secondly, if Parliament fails to facilitate adequate and meaningful public participation and consultation, then simply on that ground, a bill is unconstitutional. And in this regard, Parliament actually adopted its own parliamentary model for what must happen in order for a bill to satisfy adequate and meaningful public consultation. And this did not happen. And what is really unfortunate, Pradan, is that the Constitutional Court, no less than 5 months ago, issued a judgment in respect of the Traditional and Khoisan Leadership Bill. That particular bill was unlawful because of a lack of adequate public participation. And the court very clearly spelled out what are the criteria that needs to be met in order for a bill to be successfully said to have passed adequate public participation. And this did not happen in respect of the Cannabis for Private Purposes Bill. The National Assembly dismally failed in their duty to facilitate this.
Now, Ras, I mean, you've been at this for quite some time, you and the fellow society. I understand that the next step, that was in the National Assembly, it now has to go to the NCOP, the National Council of Provinces, in terms of the parliamentary process, where it could, depending on how the debate goes there, suffer more changes. And if it does, it will be taken back to the National Assembly. Do you see an opportunity for yourselves with the NCOP to lobby for the changes that you would like to see in order not to go the whole hog into court?
But again, now this is something that unfortunately that's lawyers only will be aware of, and that is if a bill is tagged Section 75, right, then it means that notwithstanding what the NCOP finds, the National Assembly is not in law obliged to accept those changes as recommended by the NCOP.
I see,
and
I
because
see.
The bill,
I see.
Because the bill is tagged 75, it would mean that even if the NCOP differs and they direct that the bill go a different course, the National Assembly is not obliged to accept that, and they may still pass the bill by a general majority. Whereas if it was a Section 76 bill and the NCOP charts a different course, then the National Assembly has to pass the bill by a 2/3 majority, which they, in that event, currently it would stand that the ANC government might not be able to pass this bill.
So what are the options now you've got? I mean, are you going to wait for the NCOP to conclude and see what is a finality? Or because it's been tagged as a Section 75 bill, you're already anticipating court action?
The only hope in that regard would then be that it is the prerogative of the state president of South Africa to refer the bill to the Constitutional Court after it is been assented to and ask for him to sign it. Before he signs it, it is his prerogative to refer this bill to the Constitutional Court to decide as to whether it complies with our constitutional standard. And in the event that that does not happen, then it is up to civil society, people like ourselves, to challenge this bill in court. Because technically as it stands, any court challenge would be prohibited until the bill has been assented to by the president. And like I said, we definitely do not want to go the court route, because the court will only refer us back to the National Assembly to do the job which they're supposed to have done. I mean, but then this bill is now in its 5th year. By contrast, Germany introduced their bill into their parliament in August 16. They plan to pass this bill, if not before the end of this year, early next year. So it took them 6 months, whereas for all intents and purposes, it's going to take us at least 6 years. That is unacceptable in a constitutional democracy such as ours.
And the battle is not over, according to you. While you welcome the fact that there's been this progress made, you still believe the bill does not go far enough, and perhaps it's under a wrong constitutional provision. Thank you very much, Gareth Prince. I'm sure we're going to be talking to you in the near future as this process continues to unfold. He's the chairperson of the Cannabis Development Council of South Africa.